Good morning and welcome, ladies and gentlemen. Welcome to all our viewers across Facebook and LinkedIn. Today is quite a special day. It is the first 2026 live stream event. Obviously, we're streaming here on our platform. I'm joined today by Jaundré Kruger, our National Manager, Renette Badenhorst, our Dispute Resolution Official in the Free State, and Keanu Ward, also in the Free State. The two of them are here from the practical side of things. They're in the CCM and bargaining councils every day. They're feet on the ground. They're dealing with our employers, dealing with our members. We've got our resident expert, Jaundré Kruger, over here to be dealing with the more complex questions. And I will be having fun with them, grilling them a bit on 2025's most Googled labor and employment law questions. So something that I came across at the end of last year, and just by the way, my name's Carl Ranger, Head of Training at CEO, as you can tell from the screen, just before I forget to introduce myself to all the viewers. Something I came across, and I wrote an article about it in January actually, was the most Googled questions that we found that employers would be asking. And the whole premise of today's live stream is, a lot of people don't pick up the phone to phone their internal labor consultancies or us here at CEOs, the employers organization. They go to Google, and we want to try demystify some of the questions and answers that employers are asking the internet. Because as with AI, as with Google, you're getting information, but is it the correct information? And where can you verify that? Obviously, CEO, us at CEO, we write many blog articles. We publish them weekly. So that is a good place to get sound labor law advice. But we want to unpack some of these live for our viewers today. So with that said, I'm going to jump right in. I want to open the floor live to our Facebook and LinkedIn viewers. If you have any comments or questions, please feel free to put them in the chat. We really want to encourage some engagement. We are here for the hour at your beck and call to answer whatever questions you may have. I will facilitate that from the background of here in the online studio. And let's have fun with it, guys. If you have anything, please shoot away. Jaundré, I'm going to start with you. How are you doing? Welcome back.
Yeah, thanks, Carl. What a great place to be back, and to be joined by a few colleagues. I see the Free State's representing, the panel here today, which is fantastic. And thanks for having me again. I think, as always, I love the CEO Academy part of our organization. Giving back to not just the members, but the general public as well. So now I'm looking forward to the year. You guys must have a look on our social medias. We will be at a few universities as well, maybe 1 or 2 golf days for the members as well. So welcome to everyone. Looking forward to the year, Carl. And we're looking forward to today's chat.
Great stuff. Always a pleasure having you, Jaundré. Keanu, Renette, you guys first time on stream with us. Welcome. Very excited to be having you guys here today. Renette, how are you doing? You well?
I'm well, thank you, Carl. Thank you for having me. I'm very excited to see what today is going to entail.
Always a pleasure. I have some trick questions up the sleeve for you guys. Keanu, same to you. Welcome. Always a pleasure having you. Just for reference to our viewers, Keanu is one of our experts in technicalities, technical points, always coming with interesting scenarios. So Keanu, very hearty welcome. Looking forward to having you today and giving us some of your expertise.
Thank you, Carl. Thank you for having me here. It's actually quite excited to be here. Throw what you have, Carl, and then let's engage on it.
Great stuff. I just see from a technical point of view, one of our LinkedIn users over here says they don't have any sound on their side. So what I'm going to ask just from the background, our IT team in the background, if you can just check that out for us. All right, without further ado, all right, I'm going to jump right in. So Jaundré, first quick fire question for you. In 2025, obviously, wild year for labor and employment law. We had the shared parental leave, constitutional court judgment. We'll get into that. We had the new code of good practice, a few amendments. We had the, the employment equity updates and amendments. From your side, from your perspective, what did you find to cause the most confusion for employers?
Yeah, Carl, look, we obviously have the benefit of having, a large member base, and we have a bunch of, CCMA matters throughout the year. And we obviously get to encounter real world problems that employers sit with. I think if you really take it and you don't just want to speak about the internal labor, but you want to speak about the confusion as how to deal with internal labor. I think a lot of the confusion came with the implementation of the new Schedule 8, the Code of Good Practice, and where it does seem to want to lessen the burden on employers as to what type of procedures you need to implement. And it really wanted to, I think, and I think we've done previous live events on this, what the intention was to maybe make it easier for employers to deal with, especially the smaller employers, how to deal with internal labor and the procedural requirements therein. But I think the thing we found is, well, on the one hand, employers are still stuck in the old rigid system that we've all been brought up in and trying to implement the new procedure. So I think that's where the confusion comes in for me. How do we implement the new schedule? And are commissioners at the CCMA actually going to be as lenient as the new schedule would like? So I think what we're going to need to wait for is a few test cases. I think everybody's weary as to doing too little versus too much. And I think that is where the confusion comes, that fine line between, listen, I still need to run my operations as an SMME, which is the bulk of our employers and members, and how do I deal with that and make sure that I'm still safeguarded when I do go to the CCMA. So I think that's where a lot of confusion came in. I don't think we have all the answers yet. It's a developing story. But luckily, we'll keep on updating our members as we go forward. So that's been the contentious one for me. But I think it should iron itself out in 2026. So hopefully when we do the first event in 2027, we have a clear framework for our members and viewers overall.
Great. With that, we actually have a few questions that I've documented from last year's most searched questions that actually relate to a few things you've touched on, so we'll unpack them. But Keanu, you're on the ground, you're dealing with employers at the CCMA. What did you see as a trend maybe showing up from last year regarding the most confusion?
Carl, thank you. Now it's not so much about with the new, like you said, the new schedule or the parental leave. We haven't had any issues with that, or I haven't dealt with any of such cases yet. But most of the confusion we deal with is compliance orders where employers are not aware that maybe the rate changed. Like we're dealing with compliance issues for bargaining councils. So normally, like for instance, private security, they have a new rate that is published from March, or that is enacted from March of each year up until the end of February the following year. Now, some of the employers, they forget to amend that rate, and then sometimes we get a lot of compliance issues just with that rate that wasn't changed. And I think that is something that we struggle with the members. But yeah, that's what I have now from my side. That was some of the issues that I've accounted for last year.
Okay, great. No, so that is something we can definitely talk about. I think I also saw from my side, and especially in the bargaining council sphere, a lot of compliance issues taking place. And it seems to be the same problems that are repeating themselves, maybe in a different form, but it all comes down to, maybe employers not having the correct information or being able to, up the rates as per, what the industry standards are versus, what is feasible for my, company or my organization or my industry. Renette, do you tend to agree with that, or where are you at on that?
Yes, no, I agree on that. We have a lot of compliance issues over the last few months. But another thing that I also noted, a lot of people, or something that I've dealt with a lot last year, employers, they will get a CCMA referral, and the first thing when you speak with them, they will say, but it is a casual worker. I think there's a lot of, misconfusions on that, because we as labor experts know if you work more than 24 hours in a month, you are considered as a permanent employee, whereby they will instantly say the person is only a casual. I don't need a contract for that person. I don't have a contract. I don't understand why they took me to the CCMA. So that was one thing that I saw in a lot of cases. It's usually those people that take the employers to the CCMA, and then not everything is in place because they did not maybe know the law under the Basic Conditions Act if you work more than 24 hours. So I think the importance just to get the contracts in place for every necessary employee that works for you, whether the person works twice a week with you, for example, domestic workers, to get all those stuff in place for avoiding the issues that might arise at the CCMA.
No, I 100% agree with that. I think what I'm hearing from both you and Keanu is a common theme or thread of saying, you know, these kinds of disputes can be avoided if you comply, and I'll use the word comply for compliance disputes, also regarding, you know, domestic workers and complying with the correct hours and having contracts in place. If you can comply and have the correct information and make informed decisions from the beginning, you can even possibly avoid these kinds of disputes. Yeah. All right. So, with everyone having a bit of a warm-up introduction to what the most confusion caused, or was caused, I'd like to actually just jump onto something a bit off script over here, and it's something that has recently come up now as of last week, and that is the amendments to the National Minimum Wage Act. I think it is something important to discuss off the bat. This obviously is going to be implemented from the 1st, or effective from the 1st of March 2026. Jaundré, what are your opinions? So I've got it open on my side. I'm not asking you to, you know, verbatim know all these things out your head, but the wage has been increased to 30 Rand and 23 cents for ordinary hours worked. What is your stance on that? I know it happened, it snuck up on me a bit quickly. I didn't expect it to be announced last week already. I know usually 1st of March is the effective date, but it kind of just slipped through the cracks for me. And when I saw it, I was like, okay, this is happening. And, you know, we need to get something out for our employers as well. What's your stance?
Yeah, look, it's, the national minimum wage has, I think, been contentious since the beginning in, you know, about 2019 already. It's a fine balance. You know, you're sitting with a rising costs of everything. You know, even as the fuel fluctuates and as the interest rates fluctuate, it just doesn't feel like when I go to the shops, you know, there's much of a decrease in prices. It feels like everything is just constantly going up. So I think from an employer's side, your first reaction to the national minimum wage being raised is, oh, you know, more overheads. You know, my wage bill is already my largest expense. What do I do? But now you have to look at the other side of the coin. And if you really go and calculate what you get per month, if you have a 45-hour, if you are lucky enough, let's say, to have a five-day work week and you have a full month permanent employment, what does that actually mean? And how does that translate into me, one, looking after myself, looking after my family, children at school, transport, electricity rising? You know, where does it really go, and who tends to carry that? Now, I have been very outspoken in previous videos as to my opinion of who should be carrying the cost of the vulnerable and the cost of the impoverished in this country. But unfortunately, again, and not unfortunately, but again, it falls to the employer. The employer is the one who is required to keep this machine going. The employer must make more money. The employer must employ more. The employer must pay more. And that is unfortunately the society we are in. If it isn't for the employers caring for the vulnerable and the impoverished, nobody's gonna. So it's always hard. It's knee-jerk. I think by now we know it's coming. You need to budget yourself into that. You know it's coming. You know it's going to be a percentage close, between about 7 and 10%. Prepare for it. I must say, previously we had from our employers a lot of backlash, saying, and we've you know, immediately had to reduce employees and stuff like that. I think it is easing out. I think the modern South African employer is becoming more adaptable. He's getting ready for this. He or she is getting ready for this. So we are ready. I think, again, who's going to suffer? The very impoverished, the domestic workers, the farm workers. Those are the proper blue collar workers. They're the first ones who are going to suffer, because ultimately employers cannot cut on operational costs anymore. There's nothing more to cut. They cannot cut due to the crime rates on insurance. They cannot cut on you know, making sure that the electricity and everything, even with all the backups that have been done with solar register, and now you need to register your solar. Unfortunately, that's the only place the employer is going to cut. So double-edged sword. I think it is necessary. We need to uplift those impoverished employees. But as always, the employers are going to carry the brunt of it. That's my opinion.
No, I agree with that, and I think my empathy actually lays with the employees. On the national wage, with the rising costs of everything, it is extremely difficult to get by, and it's wonderful that so many employers really make room to employ the vulnerable and all of that. With regards to that, and something that happened a couple of years ago, but something good from what I see is that they're keeping the domestic workers and the farm workers on the same rate as the national wage. Previously, and I'm not sure if employers or viewers know this, there was a differentiation between the national minimum wage and then at a lower rate where farm workers and domestic workers came in. So I think overall across the board, that is a positive change. And it's nice to see that is keeping level with that. Renette, Keanu, I don't know if you have anything to say about this, but I will give you guys the floor in a bit. I just want to jump onto our next question, and maybe Renette, this one's going to be going your way. You made a mention now about employment contracts and domestic workers, and I think this ties in nicely with the national minimum wage. But what, in your opinion, are some common mistakes that employers make around employment contracts, specifically when they're not in place? So verbal contracts, I know we have a lot of disputes across the country at CEO that we deal with where, we're looking for contracts as evidence, and it tends to be a verbal contract, and that's where the basic conditions of employment comes in. But I don't know, what is your take on that?
No, thank you, Cole. I think I touched base when I mentioned earlier what I felt I dealt with the most. But I think the common mistake with absence of a contract is where people mistake the employee for a casual. That's something that I've seen the most at this stage. Usually when an employee works with them more than the normal, or is seen in the employer's eyes as a permanent employee, a contract will usually be in place. The absence of a contract, what I've noted commonly, is where the employer sees this employee as a casual. And I think that is something that the most employers don't understand, is that, if someone works more than 24 hours in a month, they are seen as a permanent employee, and you still need to have a contract in place. That is where the cases get a bit difficult at the CCMA, because if there is no contract, then there's nothing for us to rely on, firstly. And then secondly, if there's a verbal contract in place, it can be a case at the CCMA where the employee denies certain clauses or provisions in the workplace, and that's why a contract is always necessary, or just better for us at the CCMA cases. But I would say the most common where contracts are absent is where the people mistake the employee as a casual. So I would say that is the most common thing. And how to go about it, I would just say, have a contract for people working more than 24 hours. It's as simple as that, because then you are covered. Even if they work 2 to 3 days a week, have that contract in place. There's different ways how you can structure a contract, even if someone doesn't work the 5 days per week as the usual employee.
I think something that I took from my candidate attorney days very quickly was when you consult with the clients, and it 100% applies to our members here in labor law as well, is, whatever you do, reduce it to writing. It goes from the legal side of things to the business side of things. Even if you are employing someone for less than 24 hours a month, there's no harm in having a contract setting out those terms and conditions. Then it doesn't become a he said, she said kind of situation at the CCMA. And unfortunately, a lot of those disputes fall back then on witness testimony, how strong your witness is. And it doesn't necessarily come out at the end with who is telling the truth and what the truth of the matter actually is. It's just who testifies better and, what story is more believable. So there becomes a huge issue with that. But no, thank you, Renette, from your side. Still on contracts, Keanu, another question that was asked was, and I'm generalizing the questions now. I went and looked at them, and I've just sort of amalgamated them into more of a general statement that I would like your comments on. But this deals with salary deductions, pay cuts, and withholding pay. A lot of the questions that were Googled by employers is, when is that lawful and when is it not? So we're talking about, Keanu, to you, salary deductions, pay cuts, and withholding pay. I know we have issues, with employers at the CCMA where maybe someone is dismissed And because they've now referred a matter to the CCMA, the employer becomes uncertain as to what the rights and obligations are. Do I carry on paying this person till the last day? Do I not pay them until the CCMA case is done? Where are the legal obligations and duties on the employer there, Keanu?
Yeah, no, thank you, Carl. I just want to quickly just also touch there where what Renette explained with the absence of a contract. Normally, we'll also deal with employees that referred matters, and then there's no employment contract, and then the employer will say, "Listen, this guy was on a fixed term contract for 3 months." Now, in the event when there's no contract, then the commissioner is going to follow the BCA. Now, the BCA defines the employee as a person who works 40 hours a month for consecutive of 3 months. So if an employee worked for 40 hours a month and it was for consecutive 3 months, then he's seen as an employee, permanent employee. So I think it's very important to have an employment contract in place. It just covers you as an employer, so that you know that this is the rules and regulations and this is the employment contract that you have implemented or that you have given the employee, and then that will always protect you when you go to the CCMA, because then you have a guideline that this is the terms and conditions of the employment. Now, to come back to the deductions, yes. Normally, when you deal with deductions, when it's lawful, there needs to be an AOD, so acknowledgement of debt, and the employer is only allowed to deduct 25% of the employer's monthly wage or monthly salary. So when you deduct more than that, it becomes an unlawful deduction. So for it to be lawful, there needs to be an AOD, acknowledgement of debt. Sometimes there's hearings. If you have a hearing, maybe if the guy refuses to sign, you put him through a hearing, then normally the deduction or the damages, whatever the deduction might be, will be part of a sanction, or just to inform the employee, listen, this was the damages that was caused, and now then the employee can deduct that. So yeah, the threshold is 25% of the employee's salary or wage, and normally there needs to be an AOD for it to be lawful. Now, I think Carl also mentioned withholding pay lawfully. Sometimes employers include a clause in the employment contract, but that's just a normal law of contracts clause where the notice period. So sometimes we deal with employees that just resign with immediate effect. So if you work for 6 months, you are required to give 1 week's notice. If you work for 6 months up until 12 months, you need to give 2 weeks notice, and then 12 months or a year and more, it's 4 weeks notice. So normally they'll put in a clause there where if you resign with immediate effect, the employer is allowed to deduct or withhold payment in lieu of that notice period. So if it's in the contract, then and the employee signed it and acknowledged it, then it can be lawful, or it is lawful. But like I said, it's a normal law of contracts clause. It's not what the BCA basically says. There's nothing that the BCA has in the act that stipulates that. But yeah, I think that's about it. Carl.
So I just thought of an interesting situation, and we do have a question over here as well. So Donald will get to your question now shortly, but maybe Jaundré, you can shed some light on this. We've had situations where an employee is dismissed or resigned, and there is maybe an AOD so acknowledgement of debt for damages caused, and maybe that was even the cause of the dismissal. So let's say it was a truck driver, they crashed the truck, negligently so, they're held liable for damages, and let's say a month later they resign if they aren't dismissed, or let's say they are dismissed, doesn't really matter. How do employers deal with that situation? Because now there's an outstanding debt on the employee side, and that termination of employment or the contract of employment is no longer valid, and call it alive. Employers get stuck now between a rock and a hard place. They've incurred damages, and the employee just says, cheers. I know obviously the civil courts and stuff come in, but maybe you can just shed some light on that for our viewership here.
Yeah, look, most of those AODs will have a clause that says what will happen upon termination. And look, there's a legal opinion and then there's an opinion as to how the CCMA will ultimately implement it. So obviously, if I have a contract saying that certain deductions can be made, my opinion is that turns into a civil matter afterwards, and I'm basically comparing the debts and I'm subtracting it. I think in practice, unfortunately, you're going to get stuck at the CCMA. CCMA is going to go back to that 25%, and they're going to say, well, the rest you have to claim civilly or through the civil thing. We've also had scenarios where when Provident Fund was still being paid out, so that's obviously now no longer the issue, where employees would agree to have the deduction taken from their pension fund payout. But in reality, if you go to Momentum or Sanlam or Liberty Life and you ask for that, they're going to tell you, no, thanks, good luck. You can claim that in the civil court. So unfortunately, we're stuck with that 25% deduction to be safe. And then ultimately you'll have to go and claim that due to the fact that that employment relationship is no longer intact and that deduction is no longer possible, you'll have to go to the civil court.
I see as well, just something before we take Donald's question. So Kathleen, you can maybe put that on the screen so long and you can just let it run. But what employers sometimes do, and wrongfully so, is when they resign or they are dismissed, these employees, the rest of the deduction is just made, the whole amount, which exceeds the threshold of 25%. And the issue there becomes, and it goes with Section 34 of the Basic Conditions of Employment Act, the CCMA no longer has jurisdiction to deal with Section 34. So I don't know, what's your take on that? No worries.
Apologies, technical difficulties. Just sorry, you broke up there. If you could just repeat that.
No, all good. So what I see in practice, and I mean, there's cases that I've dealt with as well. So just for our viewership here, and just to close that gap, when employees resign or dismissed and there is still outstanding amount, sometimes employers don't go to the civil court and they just deduct that full amount or as much as they can. So it exceeds the 25% threshold as per the acknowledgement of debt. It's in violation of Section 34 of the Basic Conditions. But now there's a caveat. Labour Court has ruled that Section 34 and the CCMA don't go hand in hand anymore. Labour Court deals with jurisdiction for those deductions. So I don't know, what's your opinion and advice there?
Yeah, look, unpopular opinion, the man with the money in the hand is always in the better position. Not that we would ever advise someone to go against the act. Look, that's how the law works. The precedent is clear from the court that they have the jurisdiction to deal with that deduction dispute, which in reality will make it very difficult for the employee. But your hurdle is the commissioner going to interpret it as that? So funny things happen at the CCMA. In essence, that deduction will need to be argued at the Labour Court, which would cost an employee, especially a vulnerable employee, a lot of money, which they probably don't have, as well as a lot of time. So in practice, it's difficult to regulate that or to get a remedy from an employee's side. So that's my comment. I cannot advise, I think, during a live event.
Yeah, and legally so, obviously that is in violation of what, how Section 34 should be interpreted. Just one last question on this topic over from Donald on LinkedIn over here. Is that a deduction of net disposable income? And then it just goes further. Surely it cannot be a deduction in a taxable income. So Jaundré, just your comment there.
Yeah, generally that deduction will be on the net amount. Obviously, I mean, the tax man wants his money.
Great. Thanks, Donald. I hope that answers your question. If you have any follow-ups, please feel free to shoot them. All right, moving on over here. Keanu, you are a stickler for overtime, public holiday pay, working hours. You wrote an article about it recently. It's on our blog. Where do employers go wrong here?
Thank you, Carl. Overtime. So overtime is not a must. Normally, when you deal with overtime, the employer is required to have an agreement with the employee. So normally in the employment contract, you'll have a clause where it states that, the employee will be required to work overtime and so forth. And sometimes the employers forget to renew the overtime agreement. So the law states that an overtime agreement it should be renewed on a yearly basis. So sometimes we have issues where we get cases where the employer did not do that. Then the applicant came to the CCMA and said, listen, I refuse to work overtime, and the employer didn't, or the employer forced me, or whatever the case might be. Then the commissioner will look at whether there was overtime agreement, and then if not, then the employee did nothing wrong. So yeah, for overtime there has to be an agreement, and then it needs to be renewed on a yearly basis. Then over time, the employee is allowed to work a maximum of 3 hours a day and then a maximum of 10 hours per week. So employers must just take note of that. And then I think that's about it for overtime. Carl, you mentioned what is the other public holidays? All right.
Public holiday and working hour limits.
Yes. All right. So public holidays, when you work on a public holiday, you will be required to pay the employee double the normal rate. So yeah, sometimes we get that where employees will work on a public holiday, they get paid a normal rate, but in essence, the law stipulates that when you work on a public holiday, you should get 2 times your normal rate. And then working hours limit. So working hours normally we work on a nine hour period for a day. You are not allowed to work more than 45 normal hours during a week. So that's the threshold. If you work anything more than 45 hours, that will be seen as overtime. And then overtime is not, you cannot work more than 10 hours overtime during a week. So yes, that's basically for working hours, overtime, and public holidays.
Unless by agreement. All of this must be reduced in writing. I know you didn't mention agreement, but it's important that these agreements are in place in writing with employees, specifically for employees earning below the threshold that is set by the Minister of Employment and Labour yearly. If employees earn below that, certain clauses or the BCA applies in totality. If you're earning above that, only certain clauses of the Basic Conditions of Employment Act apply. Renette. I have a question for you, and it's something we've discussed off camera at length regarding parental leave, the UIF entitlements and all of that. So as we all know, the Van Wyk judgment from the Constitutional Court dropped last year, and it kind of sent a bit of a shockwave. I don't think employers have really, gathered themselves and they comprehended the impact of this. But maternity leave is now no longer a thing. Paternity leave is no longer a thing. Parental leave is now a thing. When it comes to parental leave, how do you think that this position from the Van Wyk judgment has changed things for employers? And, what kind of tips can you give employers? And there's a follow-up to this, which I'll ask you regarding your opinion that we discussed off screen, which I'd really love for you to share from an employer point of view on screen, if you don't mind.
Yeah, thank you, Cole. Okay, look, I think the ruling in itself, it has its pros and cons. There's some things that I think even we don't have the answers to yet. It's like Jaundré touched on the new code of conduct. I think it's going to be a case of we're going to have to deal with it first and see how it's dealt with in certain cases. Because one of my questions also was, I think the ruling in itself, the pros is that it has created a father to also be entitled to get more time with his child. It created a gender equality in a manner which was needed, and it's in line with what the Constitution requires now. So I think it has its pros there. But the thing is with the ruling, I feel how to operate it within companies without creating admin chaos. Is how I think it affects employers in a sense that they now have to regulate. It's not required from them to regulate, but I mean, in a manner, you're going to have to regulate what one of the parents, how many months is the father taking, for example, how many months is the mother taking, how is that going to be regulated
Yeah.
to see how many months should be taken at the mother's side, at the father's side? Will it be another thing that I thought about, which I discussed with you? How is that going to be implemented? Are you going to have to phone, or are you going to have to trust your employee telling you the father is going to take 2 months, I'll take the other 2 months? How is that going to be regulated? So I think it has its pros and cons. There's a lot of good things about the ruling, but I think it can also cause a bit of a admin chaos to the employer. And there is a lot of questions that the ruling was made, but it's not now quite straightforward to an employer how to go about the new. We just know that it's parental leave, and it has its perks, but it's not that straightforward as to how to handle it now going forward. That is what I believe. And for some employers, it's going to create a bit of an admin chaos to regulate it, especially where, you know, the other parent doesn't work at all, and the one parent, for example, is going to be entitled to take the 4 months and 10 days continually. So yeah, that is what we spoke about. I don't know the answer to that yet.
More questions
but I
than
think,
answers. It's okay.
Yeah, I think it is going to be somewhat of a admin. It can create an admin chaos for the employer. And I think me and you also touched base on it, that how is the UI 19 going to work? However, that's not maybe the employer's issue, but it is something that's going to be regulated there.
You know, I think something that I'm gathering from what you're saying is it opens up the employer to a lot of abuse, because there's not just one employer now who's involved. There's another employer. How do they liaise? Where's the sort of the proof or the standard there? How does UIF play a role? How are they going to regulate it? And I mean, if we just look back a few years to TAPS with, you know, the COVID regulations, how much abuse and corruption was going on with that. Jaundré, I see you're itching though. What do you want to say?
No, look, it's. I think it's a win ultimately for the new ways a lot of families are structured. You know, and I think it's one of those. The buzzwords is the gender roles, you know, are no longer as defined as always. How I think it would work in traditional families, probably still the same. But as Renette's saying, you know, and not just the questions, like the UIF Act hasn't been changed. So there's no real, I mean, the mother of the child can still, or depending on certain relationships, UIF is still limited to certain individuals. So it hasn't been included, or it hasn't been updated to include the father. So it's all good and fine. You now take this parental leave. For the father, there is unfortunately no benefit from a UIF standpoint. So let's start there. Pie in the sky, great, new policy, have fun. But unless your company is paying full maternity, they were paying full maternity benefits, which I just want to warn our viewers and members, it could be seen as unconstitutional if you now don't allow that same policy to apply to fathers or the other individual within a relationship. So that still needs to be updated. And then just my but ultimately, I think, and the policies that I have seen come across my table, and you know, from other labor organizations, from larger employers as well, is there is a lot of onus placed on the employees for the good relationship and that truthful relationship with employers. So what a lot of employers are doing is, if the other parent also wants to take leave, they need to submit either an affidavit or proof of the other individual taking leave within their organization. So I think that basis of trust between employer and employee will remain. Yes, there will be space to abuse, but I mean, that's the part of any act, especially within the labor sphere. So let's see how it gets implemented. On a personal note, my wife now has 4 months, 10 days leave, not just 4 months. So that's what I've been told. So on a personal ground level, that's where I'm at. I've lost 10 days.
Congrats, Jaundré. I'm really excited to see you more at the office in those 10 days. Keanu, your take on it quick before we move on.
Yeah, no, I think Jaundré basically and Renette touched based on everything there. Yeah, I think for everyone, it's more questions than answers, but I think Jaundré cleared it up now. I also had a question regarding the UIF. How will that now work? But I think he basically just summed it up now and gave us clarity regarding that. So yeah, that's basically it from my side. Yeah.
Great stuff. No, yeah, at this stage with the UIF not being amended, it's a bit of speculation, and you can take the full leave as a father or as the other partner, but at the end of the day, you're only going to be legally paid for the current legislation, what it enacts with the 10 days. All right, ladies and gentlemen, we are just over our halfway mark over here, so I'm going to speed things along. There are a lot of questions regarding parental leave. We do have currently, I think, 2 or 3 articles on our blog regarding it, so it might answer some of our viewers' questions out there. If you do have any questions pertaining to this, you need assistance with or guidance and advice on, the policies and all of that. And, if you are a member at CEO, please feel free to reach out to us. All right. Moving on to discipline, dismissals, and probation. Keanu, I ended off with you. You didn't really have much of it to say over here. Jaundré and Renette stole your limelight. So I'll kick off with you over here. Procedural fairness. What does it look like in light of the new amendments to the Code of Good Practice? What does that look like at a disciplinary hearing? Now, I know CEO, we deal with the external labor. We had the dispute resolution at the CCMA and the bargaining council. So we are looking back to see what happened at the disciplinary hearing was substantively and procedurally fair. But from your opinion, what does that now look like at a disciplinary hearing?
Yes, thanks, Carl. I think Jaundré touched based on that just a little bit when we started. He mentioned that the new code makes it a bit more lenient towards the employer. I think it's actually it's good because if you look at farm workers, that is far from everything, the resources now to make everything formal. Now you have to serve a notice, all of those type of things. So the law has made it a bit lenient towards the employers. It just stipulated that there should at least just be a genuine dialogue between parties, and then the employee should just have a opportunity to state his case and be able to defend his case. But I think the thing that stands out is that there should just be a genuine dialogue. So the formalities has been made a bit lenient towards employers regarding all this formal notices and stuff. So I think that is good towards the small businesses and farm workers and so forth. They do not have all the resources at hand. Sometimes they have issues with Wi-Fi on a farm. So yeah, I think it is possible. It is positive towards them also. So yeah, I think that's my take on the procedural fairness is that there should just be a genuine dialogue between the parties.
On the Wi-Fi on the farm, Starlink. Anyway, Renette. So regarding what Keanu said, there's a huge emphasis placed on this. I'm play devil's advocate here. Genuine dialogue. All right. So procedural fairness for smaller business owners and employers, genuine dialogue will fly for procedural fairness. What is that? Because now, what I think is a genuine dialogue is this. I'm having a genuine dialogue with you guys. But for a commission at the CCMA, me calling an employee in saying, listen, this isn't working out. What do you have to say for yourself? Off you go. Genuine dialogue? I don't know. I want to err on the side of caution here, but what's your take?
Yeah, while Keanu, thank you, Cole. While he was speaking, there was also a few thoughts that popped up in my head, because I think it's what Jaundré said. It is quite, we're going to have to see how it's going to play out once we deal with cases like that, because is a commissioner going to accept that you said you had this genuine dialogue with this person? I don't know. At this stage, I don't know. The code is amended. It is accepted now. What I thought by myself while Keanu was speaking, and he used the scenario of a farm worker, and I'll take a domestic worker as well. I think it's just important. What I've seen a lot with farm workers also, when they maybe say the person resigned, or for example, they will already draft the resignation letter, but the resignation letter will, for example, not be in the language of that farm worker. I think the dialogue, it must be very important that they understand what the dialogue is about, and maybe have an interpreter there, another farm worker that speaks his language, because from your side, you can think you had this genuine dialogue and you followed and you explained everything, but there is maybe a language barrier, for example. So I think for me, if we are now saying this is a genuine dialogue, if I can't even understand what you're saying to me, I think that is the first thing where they will come to the CCMA, they will say, yes, we had this discussion, but I had no idea what it was about. I didn't understand the content of the conversation. So to ensure that there's maybe an interpreter there, because then you also have a witness to call at the CCMA to say, listen, this is the person that was with me at the dialogue. He assisted, and he can also be called. So I don't know if this is, like I say, maybe to keep also a written type of proof of the dialogue to say what happened there, let them also sign it. It is more informal, but I think just to have some kind of documented proof that the dialogue did take place, and there was an interpreter there, and for the applicant or the employee to sign that written document, just to have something to rely on at the CCMA. Because I think if we're going to go and say it was only this verbal discussion, it's going to be a he said, she said situation, which we spoke about earlier. So I haven't dealt with it like that before, but my common sense is telling me maybe just document it on a paper, and the most important thing, to have an interpreter there to just understand, let the employee understand what the conversation is about. Because I mean, in a dialogue, you need to follow what's happening. So yeah, but like I say, we're gonna see how it's gonna play out. I haven't dealt with that as of yet, but that's what I think.
Yeah, from what I see from the training department side of you, and I sort of have a general overview of how the cases are running in the country from CEO side, I don't really see many popping up with this genuine dialogue. I'd also, as an employer, be very, hesitant to have what I determine as a genuine dialogue, but I, of the beholder, a commissioner, might not deem it so. So what I'm gathering from what you're saying, Renette, is, rather formalize this as much, keep it as informal as possible on a small business or a small employer or business scale, but formalize the genuine dialogue, record it, write it down so that you have that proof. And I mean, that's just solid advice going across the board. Jaundré, I'm not neglecting you. What is it? What would you like to say?
Now, look, I think especially when these conversations pop up and in the limelight of the new code of good practice, and again, I'm going on my experience and my opinion, so don't take it to the bank per se. But I think if we separate the procedural and the substantive fairness too far, I think we might get a little bit lost. So if you go and look at what I need to substantively discipline an employee, was there a rule in the workplace? Was it broken? Was it known? And I mean, even with the additional elements now, I know there's two additional elements, but the one would be, what's the impact on the employment relationship or the workplace? You still need to, during your dialogue, address those substantive issues. So even though the dialogue sounds a lot more informal, you cannot take that away from the substantive requirements. And if you pull in those substantive requirements and you're hitting those points, I believe that dialogue would suffice. But if you're going to take the word dialogue on its face value and say, well, listen, we had a chat and sorry, you're gone, you're gonna get a hiding. Unfortunately, you will, during that dialogue, need to engage the employee and say, okay, well, there was a rule, you were aware of the rule's reasonable, you've broken the rule. This rule has affected our relationship to such an effect that there's no longer a trust relationship. And ultimately, I believe that transgression has or warrants a final written warning, dismissal, that type of stuff. So it's to be seen. But I think when you look at the word dialogue, go over the fence to substantive fairness and see, is my dialogue hitting the requirements? And I think then you're there. I think what they've tried to do with the word dialogue is tone down these immense formal chairperson sitting, prosecuting criminal court type of vibe. And that's what they're trying to do. But if you separate the substantive elements from your dialogue, you're going to struggle. So I think that should be your dialogue benchmark, if I can coin the term.
Yeah, I think on a procedural fairness point of view, and just for our viewership, to prove a dismissal was fair, you need to have good reasons, so substantive fairness, and you have to follow the correct or fair procedure, so procedural fairness. So those are your two pillars for dismissal disputes. Now, the whole issue with the updated code is, well, not the issue, it is a guideline, but that guideline is heavily relied upon by judges in the labor court, by judges in the labor appeal court, by the commissioners of the CCMA. And we sit with the sort of catch-22. Do we take a lighter approach to it, from an internal labor point of view? So from the employers, we only see, the damage after the fact. But do you take that lighter point of view, or do you err on side of caution and rather, as Jaundré said, cross that fence to substantive elements and deal with it? There was a recent case regarding the investigation of a dispute that involved someone taking toilet paper out of the workplace, and the employer technically didn't investigate it sufficiently according to the court, and procedural fairness wasn't proved. So again, would a genuine dialogue be enough if there's also other elements to procedural fairness, such as investigation, notice to charges? Was the chairperson impartial? You're watering it down now, but it's difficult. And my advice personally would always be rather formalize it, rather have it in writing, record it, get a chairperson to sit in. If that's not possible, do the genuine dialogue, commit to it, but then formalize it as much as possible that you give the other party a chance to say. At the end of the day, the whole idea behind this disciplinary hearing is that both parties have a fair chance to state their case, question witnesses, produce evidence or whatever it is, and that for a impartial chairperson or whoever is making the decision to come to a fair and reasonable conclusion based on the facts. I just want to check over here. Okay, great. We do still have a bit of time. We are moving into the last 10 minutes of our session here, ladies and gentlemen. So I'm going to be moving on. Jaundré, I know you ended off this question, so I'll just start with you. When it comes to dismissal disputes, obviously you are seeing, all the awards around the country, arbitration awards. What do you see employers missing when it comes to dismissal disputes?
Yeah, look. It's difficult to sum it up. I think a lot of the issues we sit with is where you are dealing with different perspectives on something, and I always jump, and I know we have a very specific training catered to the element of gross, gross insubordination, gross negligence, stuff like that. I think a lot of the time employers run into a scenario where they consider something to be gross, and they miss the fact that, remember, another individual needs to assess this. So where you have a clear dishonesty or a clear dismissal or a clear misconduct element, that you can judge and listen, 1, 2, 3, this is what needs to be there. I always want to caution employers when they're looking at the element of grossness. Is it going to be viewed as gross across the board? And this isn't just advice or an opinion I want to give to employers, but also to individuals chairing internal disciplinary hearings and assessing information. What I believe is gross is not always gross to a commissioner, not even from one commissioner to another. And the Act gives them that leniency to work within their mental framework and implement their understanding of something. So that's one of the things I think employers are very, when they get you and a commissioner assesses it, it isn't actually that gross. Employers get very agitated and aggravated by that. But I think that would be a very good starting point for employers and chairpersons to consider. Make sure that if I see something as gross, it's going to be universal, and that other people are more inclined. Look, no 1 and 2 people will always see it exactly the same. But make sure that you're covering that element, and make sure that your understanding of the gross element is going to be more widely understood or agreed upon. So that's one of the things we see quite a lot from a award perspective that I now have the privilege and burden of having to view.
Apologies, sorry, I couldn't get to my microphone. No, I was going to say, while on the topic of all of this and talking about awards, and you have the blessing and the burden, we actually, from CEO side, we actually want to start a case law discussion based on awards. So myself and Jaundré will start it off, and we'll be advertising that in the near future on LinkedIn and Facebook, and even possibly in the form of a podcast. So, ladies and gentlemen, please stay tuned for that. While we're still on the topic of dismissals, Keanu, I'm going to pick your brain over here. Regarding probation, I think this is something that you don't often see it at the CCMA in case form or dispute form, but it's a question that is Googled and it's popped up here on my side. But when employers approach probation, how does it differ from an ordinary dismissal? And what is this misconception about what probation is? Employers ask, can I just let them go if I'm not happy with them? Or, from my side, is it more of a poor work performance thing? What is your take on that?
Thanks, Carl. Yeah, with the dismissal related to probation, it's different from other dismissals. So probation, if you go to the CCMA with a dismissal related to probation, you cannot object to the process. So the process is set for con up, normally with a misconduct, dismissal, or reason unknown, or whatever the case might be, you can object to the dismissal. But for dismissal related to probation, you cannot. So on the day, you will have conciliation, which is the informal process. And then after that, immediately after that, you will have arbitration. So you need to be prepared for if you have such a matter scheduled. So probation is more, that's my opinion, it's more linked to, I would say, poor work performance. Because normally when you are probation, it's basically because of your performance. Can you do the job? That type of thing. So normally when you are when you deal with this type of matters or this type of issues, you need to follow a process, whether you monitor this employee. Let's say, for instance, he's struggling with some things, and you say, no, we can't do the job. I'm going to let you go. No, you need to follow a process where you need to give this person either training on this. Is this person aware that this is the way they should do it? Did you provide them with training? Did you give them in sufficient time to correct the mistakes? And after that, if you have the consultations now with the employee, and after that it's still problematic, or the person just basically can't do the job or is not fit for the job, then after that you can have the poor work performance poor work performance hearing, where you will now basically lay your case or state your case. But for probation, like I said, there needs to be proof that this is what you did as an employer. You monitored that the employee was struggling with this and this, and you also provided them with training, and you have given them sufficient time to rectify the mistakes. And after that, only then you can dismiss the employee.
Yeah, 100%. I think there's a lot of, they call it mud in the water on probations and how people should go about them. I think the general misconception that I've understood from employers is that if they're on probation, I'm not happy with them, I can just let them go. And that definitely is not the case. So please reach out to your internal labor company, follow the correct procedures, have that genuine dialogue formally so, and reach out to us for advice as well here at CEO. Renette, while Keanu was talking, I had a thought. What are the common trends that you saw last year? So you obviously dealt with a lot of unfair dismissal matters. What did most of them relate to from the ground level of, being at the CCMA? Did you see any common trends of dispute types or anything like that from your point of view?
Okay, thank you, Cole. I would say there's a lot of different disputes. I cannot pick a obvious reason as to why people say this is the most common dismissal that occurs. But I think usually when the employees comes to the CCMA, they always challenge most of the times it would be substance. It will only be procedure when they don't understand, like I say, why they were charged with it, for example. So it's not that, it's more substance. I think the process of appeal within the internal companies, the employees usually skips that. They don't make use of the appeal process, and then they run to the CCMA immediately first, which is not for the employers. It's not that nice for them, because the appeal process is there, it is explained to them, and they don't use that. So at the CCMA, they come there and they will take any opportunity to say why the dismissal was unfair. It doesn't always mean that there is merit in what they say, why it's unfair, but they will latch onto a reason. And once we are at the forum, the commissioner is going to assist them and guide them there. So I think the appeal process is something that is looked over to, and then they just immediately go to the CCMA, and that is why usually with a dismissal case, they will go to the CCMA first instead of trying the appeal process. I cannot pinpoint a common dismissal that occurs because I think we deal with different cases and different scenarios. But something that I've noted, I have had a case where I've only had one case where the applicant actually used the appeal process. And at the appeal process, new facts came out. So that is something that I found very useful when the case was at the CCMA forum as to why this person is actually challenging why the dismissal was unfair. So I think it's something that's overlooked at the internal companies, and it can be avoided, but I don't know if it is going to get much better because they are going to go to the CCMA at first. That's what I believe.
To all the employees out there, please use the appeal process internally. You could save yourself a dispute at the CCMA. Thank you, Renette, for your time there. Ladies and gentlemen, we are running here a bit out of time, but I don't want to just rush the ending. So I'm going to give some concluding thoughts, and I'll open the floor to the viewers over here. If you have any questions, please feel free to pop them through now. I would happily take them. If there are any questions after the fact, this video will still remain on our LinkedIn and Facebook page, so you can go view it there for all of time. You can see our beautiful faces and the advice we are giving. Jaundré, I do see we have a question over here, and it relates to, looks like gross insubordination. I'll just read it over here until it's on the screen. Hi, everyone. If an employee, okay, there we go. If an employee is still in their probation period and consistently fails to complete tasks assigned to them, choosing not to deliver without valid reasons and having their tasks delegated to other colleagues, should we proceed with a performance improvement plan, PIP, or treat this as misconduct, gross insubordination? Thanks for your input. So I'm going to shoot this one to you from Lesego.
Yeah, thank you very much. And hi, Lesego, thanks for viewing. Look, yeah, it's during the probation period, it should be, and that's the term that they coin, a little bit easier, to terminate an employee. So during that process, and I think Jaundré touched on it, in your probation period, it's an assessment of you hitting, let's call it your KPIs, and can you actually get to that system? So during the probation period, if there's a consistent failure, they require you to provide the necessary guidance training, an assessment. So if you're constantly, and what I try and advise even internally our managers is to schedule with new employees every bi-weekly a meeting to ensure that, listen, we are assessing your performance. This is where you are. This is where I need you. And I'm going to give you this opportunity or this assistance to get there. And if that constantly does not hit the criteria, then ultimately you'll terminate. So that is the essence of a poor work performance improvement plan. So I wouldn't deal with it as misconduct unless there is, because you're saying you're choosing not to deliver without valid reason. So if there's a failure to comply with lawful instructions, or if there's a direct insolence or an insubordination when giving instructions, that will form a misconduct. But if it's only and I hate using it, but it comes from university, if he needs to pack 100 boxes and he just hits 60 boxes and then 70 and then 60, that is purely performance-based. I've tried to assist. I've tried to teach better box picking up techniques, and you still can't get to that 100 boxes. That is a performance issue. So if you can separate the two, but terminating an individual during his probation, due to him not getting to the target, that is purely performance improvement plan, or we would call it a poor work performance procedure. So I hope that answers your question.
Just a tip from my side, bend your knees when you pick up those boxes. You don't want to hurt your back. Thank you, Kiani, for the laugh there. And we like to take the lighter side of life. No, Lesego, I hope that answers your question. If there are any other questions, please feel free to pop them through the chat. We would love to take them. But for now, I'm just going to give some closing remarks across the panel over here. So, Jaundré, I'll just start off again with you. Anything you'd like to, some tips for employers for the year? Anything you'd like to end off with? Please, the floor is yours.
Just from our side, stay vigilant. It is make sure that you stay up to date with the changing laws. We were in a season last year where things changed very quickly. So not just from a general employment perspective, but also within the bargaining units, there's a lot of stuff going on in regards to negotiations and terms and conditions being negotiated. We are constantly communicating with our members and trying to get their mandate so we can fulfill our slogan of the voice for employers. So please keep an eye on your emails, make sure that you're up to date, partake in the collective bargaining spheres and those spaces so that we can really go and get your opinion out there, because your voice does matter, especially if it's connected to this organization. So that's it from me, and thanks for having me, Carl.
Always a pleasure to pick your brain, Jaundré. As you can see on our new shirts over here, the voice for employers. Thank you, Jaundré. Keanu, anything that you'd like to close off with from your side?
Thank you, Carl. I think Jaundré basically touched on everything. Yeah, so that's basically it. Thanks, Carl, for having me on the platform today.
It's a pleasure. I'm really glad you could join us today, Keanu. Thank you so much for your expertise and your advice. Renate, not to pick on you last, but to pick on you last, any tips for employers for the year? Anything that you wouldn't like to see at the CCMA when you deal there? The floor is yours.
No, thank you, Cole. I think just related to our conversation, make sure you have a contract, make sure you document everything, formalize the disciplinary process, even though it's still just a dialogue. Everything boils down to have your written documents or something on paper. I think that's all tip that I have. But thank you so much for having me. And yeah, thank you for the opportunity.
100%. I'll definitely be pulling on your strings again. So from my side, as you heard it here through the last hour, make sure the employers out there that you get the small things right, because those small things do add up. Written contract, a signature here, making sure that you recorded this or that. And yeah, stay safe, ladies and gentlemen. Comply. And if not, we are here to do damage control and to assist from our side. To all our viewers out there, thank you so much for your time. We look forward to doing these more throughout the year. We'll try to spice up with some interesting topics and conversation points. And please feel free, if you guys have anything from a viewership standpoint, from an employer or business standpoint that you would like to see us do, 100% will be open to your comments and criticisms. We want to obviously be there as the voice of employers to all businesses and employers in South Africa. So from our side, thank you so much for tuning in, and we'll see you again, ladies and gentlemen. Thank you. Have a wonderful day.